Page 16, Raven Queen, C371483. Ms. Queen is present in custody with Mr. Maningo and Ms. Erickson, and then we have Mr. Portz for the state. This is on for a motion. Yeah, let me make sure I don't call the wrong thing. Defendant's motion to readdress custody status, state's opposition to defendant's motion and counter motion for proof evident presumption great finding and a no bail hold. I had continued it last time, ultimately for you guys to file written opposition. It looks like none was filed, and so I'm going to ask for just oral opposition to that proof evident presumption great finding. So having read everything, Mr. Portz, do you want to be heard on your request for a finding that I find there's proof evident presumption great any further?
Just that Your Honor has already made the same finding as to the co-defendant, Mr. Butler, and Your Honor went so far when setting bail prior to the murder charges being set here to highlight how overwhelming the evidence of guilt is in this case. You've only received additional evidence of guilt tying into this crime, and so we would ask that you make that finding since you had deferred it previously and pulled through without bail.
Okay, and so either Mr. Erickson or Mr. Maningo, did you want to address the state's request that I find proof evident presumption great at this time? And then ultimately, if I don't find that, we would address your resetting a bail motion.
Yes.
Okay.
If I may, Your Honor.
Yes.
Thank you. And thank you for continuing it. I had some medical procedures that had to be taken care of.
Okay.
My only argument really is, Your Honor, that it's premature to make this finding. And here's why. I think the court's familiar with the facts in this case. And the defense intends to contest whether or not this is even a homicide. I had hoped in the interim from the last time we were before Your Honor to today to be able to offer a proffer from an expert, but yet we haven't been able to fully accomplish our expert consultations and get any sort of finding to offer the court yet. But to summarize and make it as short as possible, the delay from the event to the actual death causes us some real concern and some questions as to whether or not the death is even related to the events and whether it was caused by the events. So with respect to that, we would suggest that the proof is not evident and the presumption not great with respect to the homicide, which is why the state, I believe, is suggesting to the court that there be a no bail setting. So if the court is going to follow suit with the prior finding of co-defendant, at worst, we would ask that we be able to revisit that issue with respect to any expert findings we can offer this court, or at least a proffer. We may not have actual findings yet because we don't know what's going to come until the time of trial, but we can make a proffer with respect to that. So our position today is that the proof is not evident, the presumption not great with respect to the homicide, and that there should be a bail setting for this.
Okay. And that was always my concern, and that's why I ultimately continued the co-defendant's matter to review the coroner's report as well as the coroner's testimony at the grand jury finding, or at the grand jury hearing. Ultimately, from where I sit right now, I have the coroner's autopsy report and the uncontroverted testimony of the coroner and his findings there that indicate the homicide was caused by that 1/12/23 home invasion beating. The report accounts for the multiple discharges from multiple medical facilities and the fact that the death occurred 8 months later, but still finds that it is a homicide as a result of that incident. I've also considered the grand jury transcripts as a whole, the GPS data and call detail records, the messages on social media attempting to sell the victim's items afterwards, cell phone records, including the text messages between the co-defendants and Ms. Queen. And I do find that this is enough evidence that the court's compelled to find that the state has made a finding of the essential components of first-degree murder sufficient to defeat a defendant's right to reasonable bail under Article 1, Section 7. There's nothing before me at this time to rebut that. I find there is proof evident, presumption great. Accordingly, Ms. Queen's bail is revoked and she's to be held without bail. The state is to prepare the order. If there is a finding that rebuts that obviously I have nothing else in front of me.
I understand. And
so if there's a finding that rebuts that, obviously you can revisit that at another time. I think that would be a change in circumstance sufficient to revisit. But at this point, it is I've found proof evident presumption great, and it's going to be a no bail hold.
Can I say something?
Sure.
Can we move the microphone closer to her? Officer, it's right in front of you. I have murder when I wasn't there. How do I have kidnapping?
home invasion burglary. I don't meet those elements. I don't understand how do I have that? I was not present.
So they're charging you with a conspiracy, so conspiring with other people. And then ultimately, the actions that they do become your actions. So that's how it's being charged. Even if you're not the one who fires the fatal bullet or does the fatal beating or anything under Nevada law, you can be charged if the conspiracy is proven.
Even if I'm not there, I'm not present at all.
That is, yes, that is what the law allows. Okay, thank you.